Hello, good morning. Welcome to this lecture series on the rules on criminal procedure. So we are now in retrial. So let me share my screen with you. Okay, Rule 118, retrial. Now, what are the purposes of pretrial? The pretrial has the following purposes. Number one, it seeks to simplify the issues of the case. Now, it determines as well the testimonial and documentary of the evidence, and it prepares the case for trial. So these are the three objectives of the trial. It simplifies the issues, it identifies the testimonial and documentary evidence, and likewise, it prepares the case for trial. Now, pretrial is mandatory in all criminal cases cognizable by the following courts. Number one, the Sandigan Bayan. Number two, the Regional Trial Court. Number three, Metropolitan Trial Court. Metropolitan Trial Court in cities. Number four, or MTCCs, Municipal Trial Court, and Municipal Circuit Trial Court, or MCTC. Okay, so in all these courts, pre-trial is mandatory. Now, what are the matters to be considered during pre-trial? Meaning to say, what are the matters that shall be dealt with by the court during pre-trial? Number one, plea bargaining. When you say plea bargaining, this is where the accused is proposing to enter a plea of guilty to a lower offense. Number two, stipulation of facts. In order for the accused to be bound for some stipulation of facts, it must be signed by him. Actually, it must be signed by his counsel and the accused himself. Whereas in civil cases, the stipulation of facts need not be signed by the parties in order for them to be bound by the pretrial order as regards the stipulation of facts. When you say stipulation of facts, these are facts that can be agreed by both parties, meaning the one party will propose to stipulate for a certain fact, and then the other party is open to deny or admit the proposed stipulation of facts. The purpose of stipulation of facts is in order to abbreviate the proceedings when the parties can admit to a certain facts in a voluntary basis. Now, number three, marking for identification of evidence of parties. Now, during pre-trial in criminal cases, the prosecution and the accused will mark the evidence to be presented during the course of the trial. When you say marking, this is the process wherein the documents are assigned. For example, the contract is for example, the check in a prosecution for bouncing checks or BP22, the checks which bounce can be marked by the prosecution as Exhibit A, and then the demand letter to make good of the check as Exhibit B. So the documents will be marked. No, it's going to be assigned its particular letter for the prosecution and for the defense number. So for the defense, the list of documents will be marked as 1, 2, 3, 4, and then for the prosecution, A, B, C, D, etc. Now, waiver of objections to admissibility of evidence. You know for a fact that, for example, in the rules on electronic evidence, the original of the evidence must be presented in court. So during pre-trial, the prosecution can request that the accused or the defense can waive. When you say waiver, that means that the prosecution will no longer interpose any objection as to admissibility of a particular evidence. Now, if, for example, you remember in your study on Revised Penal Code, Book 1, you have their self-defense as a justifying circumstance, defense of a relative, or defense of a stranger. Now, if the accused will interpose a lawful defense, like for example, a self-defense, then the accused is necessarily admitting the information. No? When the accused admits the information, then there is no more need for the prosecution to prove it because it was already admitted by the accused. Now, if the accused admits the allegations of the information or the charge against him, there is no more need for the prosecution to present evidence, and therefore it will shift the burden of evidence on the part of the accused. And therefore, the trial will be modified. Yan ang sinasabing modification of the trial. Instead of the prosecution presenting first the evidence, it's going to be the defense presenting its lawful defense. Because again, when the accused interposes a lawful defense, there will be a reverse trial. And the allegations of the information had already been admitted by the accused. Okay. All right. Now, during preliminary conference, the branch clerk of court shall assist the parties in reaching a settlement of the civil aspect of the case, marking of the documents, and admissions on the genuineness and due execution of the documents. Again, the pre-trial order must be signed by both parties and counsel. Okay. Now, what is the period by which pre-trial is conducted? Under the old rule of the rules on criminal procedure, the pre-trial is conducted after arraignment and within 30 days from the date that the court acquires jurisdiction over the person of the accused, unless a shorter period is provided by special law or circulars of the Supreme Court. Now, under the continuous trial rule, the pre-trial is conducted right after arraignment on the same hearing date. So if the court will set the case for arraignment right after arraignment on the same hearing date, then the court will immediately proceed to pre-trial. Okay, so this is the amendment brought about by the rules on continuous trial in order to abbreviate the proceedings. Dati-dati ang arraignment, for example, arraignment is done today, then it can be set for after 7 days or after 14 days as the case may be. Under the rules on continuous trial, the court will set the arraignment and pre-trial in one hearing date. So let us compare pre-trial in a civil case and pre-trial in a criminal case. In civil case, it is the plaintiff who files for motion for pre-trial. So the plaintiff moves to set the case for pre-trial. Okay? On the other hand, in a criminal case, the pre-trial is ordered by the court and there is no need to file a motion to set the case for pre-trial. Okay. Now, what is notable among the distinction is that in a civil case, the court will consider the possibility of amicable settlement or what we call as compromise agreement. Okay. Now, in a criminal case, amicable settlement or compromise agreement is not among those matters which are dealt in pre-trial. Why? Because in a criminal case class, theoretically speaking, you cannot go on record as amicably settling the criminal aspect of the case. A party, a private individual, or a private person may not settle a criminal case because under our laws, a criminal offense is a violation against the state, and therefore it is only the state which can amicably settle the offense, not the criminal offense, and not the private offended party. Okay, next slide. Now, in a civil case, there is what you call as minutes of the preliminary conference. This is the listing of agreements and admissions during the pre-trial conference. In a criminal case, again, it must be signed by both the accused and the counsel. Otherwise, they cannot be used against the accused. Okay, in a civil case, if the court sets the case for pre-trial conference, then both parties will have to file a pre-trial brief. Both parties will have to file pre-trial briefs. On the other hand, in a criminal case, the prosecution and the accused do not file pre-trial brief. No? Okay. Now, the pre-trial conference order will have to contain the following matters. Number one, the court will require the private offended party to appear, and then the court will direct the parties to prepare the documents for marking to be presented during the course of the trial. And it is an elementary rule on the during pre-trial that no evidence shall be allowed to be presented and offered during the trial other than those identified and marked during pre-trial. So class, if a party failed to mark a specific evidence during pre-trial, then that party is precluded from presenting them during trial, unless and until a piece of evidence is marked during trial, then you cannot present it during trial. No? So it has to be marked. The evidence will have to be marked, identified, and marked during pre-trial. If there was no identification, if there was no marking during pre-trial, then you cannot present that evidence, no, except when allowed by the court for good cause shown. Now, plea bargaining class, this is where the accused is trying to strike a deal with the prosecution. This is where the accused would like to propose for him to enter into a plea of guilty to a lower offense. Now, this is the process whereby the accused, the offended party, and the prosecution work out a mutually satisfactory disposition of the case. Okay. Now, action of the court when plea bargaining fails. Now, if plea bargaining fails, meaning the prosecution did not approve of the proposal for the accused to plea to a lesser offense. No? If the plea bargaining fails, then the court can adopt the minutes of preliminary conference as part of the pre-trial proceedings. No? The court will confirm the markings of exhibit or substituted photocopies and admissions on the genuineness and due execution of documents and list object and testimonial evidence. No? Now, the court will also scrutinize every allegation of the information and the statements in the affidavits. Now, as to the following matters, the identity of the accused, now the court will ascertain whether the name appearing in the information is the correct name of the accused by asking the accused to produce a government-issued ID. Okay. 2, court's territorial jurisdiction in relation to the offense charge or offenses charged, qualification of expert witness, amount of damages, genuineness and due execution of documents, the cause of death or injury in proper cases, adoption of any evidence presented during preliminary investigation, disclosure of alibi, insanity, self-defense, exercise of public authority, and justifying or exempting circumstances, and such other matters as that would limit the facts in issue. Okay. The court will also define the factual and legal issues in the case, and the court can ask the parties to agree on specific trial dates. No, the court will inquire as to the availability of the parties and their respective counsels. Okay. The court will require the parties to submit to the branch clerk of court or COC the names, addresses, and contact numbers of witnesses that need to be summoned by subpoena, and consider the modification of trial if the accused admits the charge but interposes a lawful defense. Okay. Now, what if the prosecution agreed to the proposal of the accused to plead to a lower offense? What should the court do? No? The court shall issue an order which contains the plea bargaining arrived at. Second, the court will proceed to receive evidence on the civil aspect of the case. And three, the court will render and promulgate judgment of conviction, including the civil liability or damages duly established by the evidence. Okay, what happens if the counsel for the accused or the prosecutor during pretrial does not appear without valid justification? Now the court will impose sanctions or penalties on the counsel for the accused or the prosecutor. Take note, class, that the court will impose sanctions and penalties to the counsel, the lawyer for the accused or the prosecutor. Now, how about the personal appearance of the accused? During pretrial, the personal appearance of the accused is not mandatory. It is not mandatory. The accused personal appearance is mandatory in arraignment but not in pretrial. No, the reason being is that it may violate the right of the accused to remain silent. Okay. Okay. Now, the pretrial order is an order issued by the court reciting the actions taken, the facts stipulated, and the evidence marked during the pretrial conference. Now, what is the purpose and effect of the pretrial order? Once the pretrial order is issued, it will bind the parties. It will limit the trial to those matters not disposed of, and it will control the course of the action during the trial. So if a new evidence is introduced by a party and it was not listed in the pretrial order, then it will not be allowed by the court. Now, the court will not allow the presentation of evidence which was not marked, which was not identified and marked during pretrial unless modified by the court to prevent manifest injustice. So, class, I want you to be familiar with some mediation proceedings conducted in court. Now we have the court annex mediation and judicial dispute resolution. Now the court annex mediation and judicial dispute resolution, or CAM JDR, is a process wherein a pending case is diverted from a adversary proceedings to a friendly approach of compromise agreement. Now, the purpose of this is to help declug docket congestion of cases in court. Now, there are three stages of diversion of cases to court annex mediation and judicial dispute resolution. Now, the first stage is where the judge refers the parties to the Philippine Mediation Center for mediation of their dispute by trained and accredited mediators. Now, if there was a failure to amicably settle the matters as between the parties, then what happens is that the case will be referred to JDR, Judicial Dispute Resolution. During JDR, it is a judge who presides as a mediator conciliator or early neutral evaluation in a continuing effort to secure settlement. So when the judge sits as a JDR judge, it is a very, very informal and private proceeding. Now, the judge will more or less um, encourage the parties to settle, to amicably settle. No? Now, the third stage of diversion of cases is during appeal. Now, the PMC Appeals Court Mediation Unit for mediation. But this is when when the case rather was elevated on appeal. Okay. Okay, so what are the cases that are covered by court annex mediation and the JDR? So the civil cases and all civil liability of criminal cases covered by the rules on summary procedure, including the civil liability for violation of BP 22 or the bouncing checks law, no, bouncing checks act. Now, special proceedings for the settlement of estate, all matters, civil and criminal, within the jurisdiction of the revised Katarungan Pambarangay Law, civil aspect of quasi-offenses under Title 14 of the revised Penal Code, less grave felonies, punishable by correctional penalties not exceeding 6 years of imprisonment where the offended party is a private person, estafa, theft, and libel, probate proceedings, forcible entry, and unlawful detainer. No? All civil cases involving Title II or interest or possession of real property or an interest therein, and then habeas corpus. Okay. What are the cases, on the other hand, which cannot be referred to court annex mediation or judicial dispute resolution? Civil cases which by law cannot be compromised under Article 2035. So, for example, civil status. Now, this is something which you cannot be subjected for mediation. No? Other criminal cases not covered under paragraphs 3 to 6 above, habeas corpus petitions, and all cases falling under RA 9262 or VAUSI. No? Okay. Cases with pending application for restraining orders or preliminary injunctions. Okay. Now, the appellate court mediation, this is the one which is applicable when the case reaches the Court of Appeals. So this ends our discussion. I'll see you again next meeting. Thank you.